Hello. Good morning, everybody. Happy Saturday. Thanks for joining. This is Being Civil in Minnesota. I come here every Saturday at 10 to talk about rules of family court and to talk about the court process. I am an attorney licensed to practice in the state of Minnesota. This does not mean I'm giving you legal advice today or that I'm going to be your attorney. I think there's a lot of good information out there, and I want to make sure that people are being put in the right direction. I had 3 different members post questions this last week, so thank you for doing that. The engagement really helps me come up with topics, and then I know that the information is relevant to what's going on in your life. So if you have any questions or issues that you want to cover, please go to the Facebook group Being Civil in Minnesota and let me know if you have questions. You can post anonymously, so you don't have to worry about sharing any personal information that you may not feel comfortable sharing. So we'll just get right into it. 2 of the questions had to deal with drugs, and one of them had to deal with jail. So first one was asking about a missed drug test. Somebody wanted to know, what are the consequences for another parent who misses a drug test? In the state of Minnesota, the court does issue orders based on what is in the best interest of the children, and that does include looking at the physical, mental, and chemical health of both parents. If there is a provision in a court order requiring drug or alcohol tests, it's typically there for a reason, and so it can be very frustrating when those safety measures are not able to be enforced. And they wanted to know, well, what happens if they miss a drug test? And a few people talked about their experience. Unfortunately, some of them had experiences where missing a test was less problematic for the other parent. They just continued to go unfazed on their supervised parenting time with apparently no intention of moving on to the next step. But that's really frustrating to the parent who's at home with the kiddo and having to house that other parent for those supervised visits. There are things that you can do. First thing you would want to do is, number 1, do you have a court order? If there's a court order for these drug tests, you can enforce a court order by filing what's called a motion for contempt. And you could also file something called a motion for parenting time assistance if the drug testing provisions are not being complied with. There may be other things a court can do to ensure either consistency in the schedule, because if you miss a visit, there are court orders out there that will say, if you don't test when you're asked to test or within this amount of time, your next visit is going to be canceled. It could also say that if you refuse a test, fail a test, or a test is inconclusive because of perhaps somebody is trying to mess with the results to pass it, you want to make sure that that order has teeth and that there's something that a court can do. So wanting to make sure that you decide, well, what is a reasonable consequence? Are we skipping a visit? Are we going to suspend, meaning there would be no further schedule for parenting time unless the parties can either agree or a court determines otherwise. So it's important, if you have concerns about chemical use or drugs or alcohol in your situation, that the order not only addresses the main concern, which is making them have to not use during their parenting time or for a period beforehand, typically at least 24 hours in advance. And if they can't comply with that, then what is the next reasonable step? I get quite frustrated a lot when I've got parents in these situations who are trying to do the right thing, trying to encourage a relationship. Unfortunately, when you have a parent who's in active use or is non-compliant with a court order that gives you a sense of security about their sobriety, that falls on you. When visits are rescheduled, you as the primary parent or the custodial parent, you're going to have to now change your plans and have the kiddo. when maybe you weren't planning on doing that. And most of the time, parents are not. They'd rather the child be safe, but with somebody with multiple kiddos, that can be really disruptive and really impact not only just the child's sense of scheduling, but also that primary parent's ability to freely live out their life without having to always wonder, okay, are they going to show up or not? At some point, I think it's reasonable to say, you might not be ready to be a consistent figure. Let's come back a different time. And judges can be very receptive to that, especially when there's a pattern of that. The next one was about drugs again also, and it was about a relapse. So if somebody is in active use and they don't want you to know about it, typically they'll probably skip a test if they think they're going to fail it. This individual wrote in and said that they were never married and they don't have a court order. They've got a 1-year-old, and the other parent has a history of substance use. And unfortunately, they found out that they are back in the in active addiction. Their experience was feeling unsafe when that individual was drinking, so they have concerns, and they want to know what to do about it. They want to know if they go to court, is it possible to have him do UAs, and will a judge look bad upon them if she stops visits? A lot of great questions. Obviously, it's going to depend on the judge and the circumstances, so I can't necessarily say exactly what is going to happen in your situation. However, in the state of Minnesota, if you're an unmarried mom, you get to make those decisions for your kiddo until the other parent goes to court and say, I too want to be a legally recognized parent. So you have the ability to make sure that your kiddo is safe, and that you can put things, hey, good morning, that you can put things in place that will enhance the safety for both your feelings and your kiddos. So this person who wrote in also had concerns about faking or passing drug tests. I've seen it a lot. It does happen. There are not all perfect methods out there, but they were seeing issues with having concerns, the person waiting too long and then submitting to a test, which clearly is going to probably impact what the results would have been had they done it on time. And so there are different things you can do. There are things called patches. It's a patch that is worn on the skin, so that way it is constantly monitoring instead of having to do those breathalyzers. There is something called SoberLink, and there are other companies as well, but they provide a breathalyzer program where you can have photo monitoring, so you know who is taking the test. I hear all kinds of crazy stories. People use air compressors in their vehicles to pass breathalyzers. They use children. But there is ways that they can put the facial recognition as well, which would be another enhanced level of safety. And of course, document these concerns. You will likely know their behavior best. If they're missing visits, if there's, lawful, unlawful behavior, if there, issues with their jobs. If and when they do bring you to court, a court has the ability to restrict, meaning limit time with the kiddos and make it supervised if they also have concerns. Ooh, do patches work for all substances? Great question. There are different patches. I certainly don't know all the patches, but there's UAs, there's patches, there's breathalyzers. So depending on the drug that you're looking for or most concerned about, you certainly want to make sure that if you are going to go with the patch, that it does detect for the substance that you are looking for. So unfortunately, I don't know the answer to that. But I have seen them work in cases where we identified the patch as a good option and they were able to identify those substances. The last question I got was from somebody who is trying to serve somebody who's incarcerated. And they tried to mail paperwork a few weeks ago. Their spouse says that they haven't gotten it, and she doesn't know what to do next. So when I've dealt with other parties, adverse parties who are incarcerated, I will typically contact the facility and try to identify who their case manager is. I will identify that I'm trying to get this individual some paperwork, and I'm seeking information from them as to how to do that in the best way possible. Sometimes they're like, email it to me, I'll hand it to them, no problem. That would be incredibly helpful and easy. If you are trying to actually legally serve them, right, the caseworker, you'd also want to send them what's called an affidavit of service. They have to be over the age of 18 and not a party to the case, but after they hand them the paperwork, then you would ask them to fill out the affidavit of service indicating that they did in fact provide the paperwork to the other party. So they wanted to know, are they going to have to bite the bullet and have them served? Possibly. The caseworker doesn't necessarily, have to do you a solid and help you out. Couple other options is you can request that the sheriff serve your paperwork. The cost for that will vary by county, but if you are low income or under a certain income threshold, law enforcement will serve that paperwork for free. To see if you qualify, you would fill out IFP paperwork. It stands for in forma pauperis, which is it's a phrase for needing a fee waiver due to income. You could have somebody who's over the age of 18 go to that facility and just hand them the paperwork. Again, they would have to fill out that affidavit of service. They have to be over the age of 18. They can't be you. They can't be a party to the action. And then you can hire a process server. Similar to law enforcement, these are it's an agency that will do a service and serve the paperwork on an individual. They will likely charge a fee for their services. But typically, that is something that's not the most expensive part of the process. And then another option would be is you could have the person, hopefully when you mailed this paperwork to the individual, you included what's called an acknowledgement of service, meaning, yes, I got these papers, you don't have to serve me personally. So if the case manager is willing to give those documents, you may want to include that paperwork, so that way the inmate can just sign and say, yep, I received it. You don't have to send anyone else here that's formal or official to provide me with those documents. So hopefully that gives you some ideas on what you can try next. If you don't hear back, hopefully you will. I just want to thank you for joining me today and for your questions. Updates for me is Maes Law is going to be moving and expanding, so stay tuned for that. This may be one of the last Saturday podcasts from my current office, and I look forward to keeping you guys updated. And take care and have a great Saturday. I'll see you guys next week. Bye.